It's a wonderful honor to welcome Paul A. Clark on this program. He is an attorney and he works for Clark Legal Services. How are you today, Paul? Thank you for joining us.
Doing well, thanks. I'm glad to be here.
I discovered a very interesting article that you wrote. It was published in 2006 in the University of Illinois Chicago Law Review. It's titled Limiting the Presidency to Natural Born Citizens Violates Due Process. And that brings me to the recent, I think it has been suspended now, campaign of one Cenk Uygur of the Young Turks fame. And we are going to focus on that topic that you've addressed, how
Right.
the natural born citizen clause of the Constitution violates due process. First, I'd like to ask you about your background in legal services. Why don't you give us a brief summary of that?
Okay. Well, before I went to law school, I got a PhD in philosophy, specializing in moral and legal philosophy. And then after that, I attended law school, went to the University of Chicago. And after law school, I clerked for a couple of different judges, both the state Supreme Court justice and a court of appeals judge. And I've been practicing law since for nearly 20 years now. So that's quick background of mine. And obviously published this article quite a while ago. Published numerous law review articles on issues of constitutional law and other areas as well.
Mhm. Uh, yeah, so this might be a very obvious question to everyone who's an American, but why does the Constitution matter?
Well, that's actually a controversial question, believe it or not. I'll give you a couple of answers. So the traditional understanding of the Constitution was it was a kind of a compact between really three different parties. So there was kind of, and that's kind of the difference between a contract and a compact. Often is this term is used to apply multiple parties. But the old understanding was the Constitution was again, it was a kind of a compact between the federal government, the state government, and the people. And all of those different aspects were again, they were parties to this agreement. And the idea was that the people of the various states agreed to form a new government in 1787, which replaced the Articles of Confederation Perpetual Union. James Madison said that the states could just leave the old union, start a new one. But in any event, they got together again. The people, the states, the federal government got together and said, okay, this is the things the federal government is going to do. And we called that the Constitution. And way back in the 18th century, early 19th century, the understanding was that the federal government had to abide by the terms of that compact. And the federal government was limited by, but it also received its authority from this agreement, this compact among these different parties. And so they thought, again, the 18th, 19th century Americans thought the Constitution was important because it laid out, it gave the federal government authority to do certain things, and it stopped the federal government from doing other things. And as John Marshall famously said in the famous case of Marbury versus Madison, so that these limitations and powers would never be forgotten, they were set down in writing. And that was why we have a written, we in the United States have a written constitution as opposed to, say, in Britain, of course, famously, there's no written constitution. The Constitution is sort of an evolving thing. It involves all sorts of different pronouncements, things like Magna Carta, the Bill of Rights of 1689, and various pronouncements. So that was kind of in England, sort of the Constitution is kind of an evolving thing. In the United States, the framers thought we put these things down in writing so everybody knows exactly what the federal government can and cannot do. So that was the old understanding. Now, the more modern understanding, which again is still controversial, many people still adhere to the old view that this is a written document. Everyone should abide by the terms of that written document as written. The more modern view, which really begins in the 1920s, is the idea of a living constitution. This is much more like the British Constitution. It's not something that's written down on a piece of paper. It's an evolving understanding. And this understanding of the Constitution is that we must reinterpret the Constitution constantly in light of new needs, new requirements. And so therefore that in this view, the Constitution is more of an amorphous concept, and it allows the a certain group of people, usually federal judges, but sometimes other people get involved as well, to basically apply this evolving standards of decency to all of society. And this was a famous case, for instance, in Furman versus Georgia, for instance, a famous case from the late 1960s, which the Supreme Court said that capital punishment was contrary to the evolving standards of decency, and the Constitution embodies these evolving standards of decency. So again, in this view, the Constitution is a fluid document which incorporates the evolving standards of decency that were in effect in the 17th, 18th centuries, and now in the 21st century. So again, it's a very different view of the Constitution, but both sides think the Constitution is important for these different reasons. And of course, there's some people who say, forget about the Constitution, I don't care, just throw it out the window, it doesn't matter. But again, you asked me why it's important, so I won't deal with the third view that the Constitution is just a bunch of nonsense, just a bunch of words on paper, nobody cares about it, and we should just throw it away. And again, there's a school of thought that says that, but again, just to be completely comprehensive, I'll say there are some people who don't think the Constitution is important at all.
Mhm. Right. And just to follow up on the living constitution point, I know that the school of originalism rose in opposition to the living constitution doctrine, and I think it would be worthy for you to explain what that school did.
Sure. Well, yeah. So again, this is a very complicated point, but let me try and summarize it. So first of all, I would say th- the idea of originalism, that was sort of always the understanding back in the 17th, 18th century, like everyone was an originalist. So originalism is more of a modern term, as you say, but it was really the theory that pretty much everybody espoused. Again, I mentioned John Marshall and Marbury versus Madison says we should interpret the Constitution as written. That's what everybody thought. Now, of course, it was easy back in 1789 and 1791, and because the Constitution is written and evolving standards of decency were the same thing. But in any event, but to your question more directly, in the early 20th century, there was a school of thought called legal realism. Now, the traditional view was judges are basically just like computers. You plug in the information, they spit out the result with no biases, no nothing, and every judge that you go to will give you the same result because they're just like computers. And again, this was sort of what people like Hamilton in the Federalist Papers. Hamilton says judges will have neither force nor will, just judgment. You just put in you give them law, you give them the fact, and they spit out the result, and every judge will come to the same conclusion. Now the realist says, well, that's nonsense. We all know that different judges come out different ways based upon their personal opinions and their personal experiences. Now, the anti-realists said, well, of course that's true. We know that, but we're going to pretend that all judges come out the same way. So there was kind of, on the one hand, was, yeah, we know that different judges come out different ways, but it's a useful fiction to imagine that all judges come out the same way. But again, the realists said, no, that's stupid, that's crazy, that's nonsense, that's a fiction. Realists said, actually, the experiences and the personal input of the judges do influence the way the courts decide cases. Now, that's sort of the descriptive aspect of realism. And realism began as kind of a descriptive theory, saying this idea, all judges are the same, is ridiculous. All judges aren't the same. Now, from the descriptive theory, we went to a prescriptive theory. The next step was to say, not only do judges determine cases based upon their own idiosyncrasies, their own personal beliefs, their own conception of justice, but judges ought to decide cases based upon their own idiosyncrasies, their own concepts of justice. Judges ought to do this. And this was really the big divide where again, what became originalist was no, judges should interpret the Constitution as written, not as they would like it to have been written. And so again, this idea of the living Constitution evolves out of legal realism in the early 20th century. And by the 1920s, Justice Oliver Wendell Holmes is often considered to be the founder of this idea of a living constitution. So in the 1920s, there was a famous case involving the Migratory Bird Treaty with the United Kingdom. And Justice Holmes upheld this Migratory Bird Treaty, basically said, I grant you the framers and founders of the Constitution would have never imagined that the federal government could punish a man for shooting a duck on his own property. Framers never would have imagined that. But today, we live in a different society. We have to apply new standards to constitutional interpretations. Again, that's the case that really it's called Missouri versus Holland. Holland, not the country, but a man named Holland. So again, that's considered to be the case that created this whole idea of the living constitution. But as I said, this went on over the years. And as I said, I think Furman versus Georgia is one of the most explicit, where they said the Constitution involves evolving standards of decency. That's what is the bottom line in constitutional interpretation, not the written text or evolving standards of decency. So again, the originalists said, well, if Constitution is evolving standards of decency based upon each individual judge's own concept of justice, and after all, remember, most Supreme Court justices are very different from the average American. Most Supreme Court justices went to an Ivy League school. They live in their own segregated communities. And, you know, many people say, well, who are you to tell us what the evolving standard of decency is? After all, you people are legal experts. You're not, you know, some kind of oracle of popular decency. But no, so again, this is the big divide. The originalists say interpret the Constitution as written. The living Constitution argument says interpret the Constitution according to our evolving standards of decency. Now, I should mention that again, there's a third theory, which was so Justice Thomas, for instance, is an originalist. Justice Thomas on the court today says interpret everything just as it is written. Now, Justice Scalia had a different view. Justice Scalia put a great deal of emphasis on stare decisis. And in fact, this is actually the most common rule today. Most Supreme Court justices are not originalists. They say that if it's a matter of first impression, that is, it's never come before the court before, then of course we should apply the original understanding. But Justice Scalia and others say, well, if there is precedent, even if we think it's wrong, even if we think that it does not correctly express what the framers of the Constitution originally meant, nevertheless, we should stick by precedents. That's the idea of stare decisis, because it's going to be too confusing to start throwing out long parts of history and going back to the original understanding. So again, originalism is the minority view today. The majority view is the stare decisis view of Justice Scalia. But again, the next biggest theory is the living Constitution theory, and then the least popular is originalism.
I understand. So moving on to Cenk Uygur. So to the extent that you follow his campaign as well as your, I suppose, personal political views, what do you make of his run for the presidency?
Yeah, I mean, I don't know much about him personally, but so I can certainly comment on sort of the legal issues. Yeah, because again, I understand he's dropped out anyway, but certainly over the years, a number of people have contacted me and said they want to run for president. So let me explain the background of this. And again, let me give you kind of the basic summary. And then if you want to get into more details, we can certainly get into specifics. So the Supreme Court has held for about the last 75 years that the Fifth Amendment says the federal government may not discriminate against anyone based upon their status as a natural born citizen. In other words, in the 1950s, was actually the 1960s, in 1964, Supreme Court said uh, the federal government must treat uh, what they call naturalized citizens and natural born citizens exactly the same. To treat a naturalized citizen differently from a natural born citizen is illegal, unconstitutional discrimination, and it must stop. So, if again, we get into more specifics of how they got to that, but the bottom line is if it is illegal for the federal government or the states to discriminate against any person based upon their citizenship status, and however they gained that status, if they all must be treated the same, then clearly any American citizen can run for president, not only run for president, but can serve as president. I should say there's actually a difference between running for president and being president, so those are slightly different issues. But again, the bottom line, discrimination based upon national origin and or status of citizenship is illegal under the U.S. Constitution, according to the Supreme Court. It has been for the last 75 years, and I don't expect that to change. So obviously then, if a citizen wants to run for president, he or she certainly can. And to say they can't would be a violation of the Constitution. And obviously anything prior, any part of the unamended Constitution to the contrary would not apply. Obviously, amendments amend what came before. So if the Fifth Amendment prohibits discrimination based on national origin, then obviously, just because prior to the Fifth Amendment, such discrimination was permissible, that doesn't make it okay. So again, clearly, anyone who wants to run for president who is a citizen, in fact, even actually not even non-citizens can run for president. They can't be president. Again, that's the difference between running and being president. But again, so that's my view of the legalities of the matter. And again, I can't really comment too much on the specifics of his campaign. And again, I think he's, as you said, my understanding is he dropped out of the race anyway. But I should say that actually I'm aware of some other people that are continuing to run if people are further interested. In fact, there is some litigation. There's been litigation on this in the courts for a number of years. And I know there is one person today, Dr. Shiva, is running for president, who is a fellow from Massachusetts who said to have claimed to have invented the internet. Again, what the ins and outs of it, I don't know, but just so your viewers are aware, there are some other people that are still pursuing this.
Okay. Well, yeah. So before we get into the constitutional aspects of it, I'd like to ask your personal views on what it means to be an American citizen, natural born or naturalized.
Well, that's itself a somewhat difficult issue because they've never been, at least I should say in the Constitution, they are not defined. Now, the courts have said since then, since the Constitution was adopted, that naturalized is you're not born in the United States or born from parents who are citizens, but you become a citizen at some time after birth. Now, again, it's not defined in the Constitution. In fact, if you go back to the Constitutional Convention, we don't know there either. Some of your readers may know, you may remember, the Constitutional Convention had an official secretary. All he did was basically just record votes. He didn't record the details of different debates. The most thorough discussion of the debates of the Constitution were Madison's notes. James Madison took copious notes over many of the debates, but he doesn't record any kind of discussion over the so-called natural born citizens clause. So we don't know precisely what it even means. And in fact, we have a contemporary situation. The Maryland legislature, all the way back in the 18th century, they decided to grant the Marquis de Lafayette status as a natural born citizen. Now, again, he clearly wasn't born in the United States. So there is some dispute and some confusion about what the phrase actually meant to the framers. Now, again, there's a whole long history in the British Empire. They had issues about naturalized subjects or non-naturalized subjects. And again, the courts have said naturalized citizen is just someone who was not a citizen at birth but became a citizen later. But as I said, whether that's really what the framers meant, we don't know for certain. There's some controversy over exactly what the phrase meant.
Okay.
So I can't tell you precisely what it means. I can just tell you what, again, in my article, I assume I take the view that the courts have taken. Naturalized citizen simply means someone who became a citizen at sometime after birth.
Mhm. Okay. Now, I studied a class in international law a year ago, and I know that there's a distinction between, was it just jus soli and jus
Yeah, the
sanguinis?
jus soli, yeah,
Uh,
the
um,
law of the soil, or yeah,
mhm. And
and the law of the birth, yeah.
I know that in America, citizenship, or at least natural born citizenship, is defined by the jus soli principle. And I read in a case involving one Wong Kim Ark, right? His parents are Chinese, but he was born in America. So the
Okay.
Supreme Court decided that he's an American citizen. So so natural born American citizen. So that's my understanding of it. So help me fill in more as to how America come to adopt this principle rather than the jus sanguinis or citizenship by blood principle.
Well, right. So the United States doesn't use those terms, although they are part of the background. But let me go through again, try and summarize quickly. So originally, so before the Constitution was adopted, actually for some years after the Constitution was adopted, the states each had their own citizens, and they could determine who was a citizen, and it varied from state to state. Now, once the Constitution comes into effect, uh, the Congress passes the first Citizenship Act, determining how people become citizens and who could become a citizen. Now, under the Citizenship Act, I think it was 1791. I could be off by a year or two, but it was early on. So the first Citizenship Act passed by the United States Congress said only people of European descent could be citizens. And again, this is obviously controversial. This is one of the issues about the Fifth Amendment, because if the Fifth Amendment makes such discrimination illegal, then obviously that would be unconstitutional today. But in any event, that was the original understanding. Now, this, of course, led to issues. There was a famous case called the Dred Scott decision in 1856, which applied the Citizenship Act. The Dred Scott decision said Congress says only people of European descent can be U.S. citizens. And the court in Dred Scott said Congress has authority under the Constitution to determine citizenship, and that's what they've said, and we have to apply it. Now, it was an open question in Dred Scott whether Congress could change that. Presumably, Congress could have changed it, could have allowed citizenship to anyone. But in any event, of course, as you know, Dred Scott was hugely controversial because many states had in fact allowed people of non-European heritage and descent to become citizens of the states and to vote and so forth. So, and in many people, this was a terrible decision. Now, one of the results of this was Congress apparently passed the 14th Amendment. The 14th Amendment says that anyone born in the United States is a citizen of the United States. Now, I say apparently because there's a whole controversy of whether it was actually passed. There's all kinds of shenanigans going on in the 14th Amendment. And I won't get into that. If anyone's interested, or if you want to follow up, we can talk about it. But assume for the sake of argument, the 14th Amendment was validly adopted. But the 14th Amendment wanted to put an end to this sort of constant subclass. So in other words, if Chinese or Africans came to the United States and they lived here and they had children, neither they nor their children were citizens of the United States under the Citizenship Act. And so the Congress on the 14th Amendment said, we've had enough of that. We don't want a permanent underclass of non-citizens. And therefore, the 14th Amendment was adopted. Now, one of the big controversies, of course, the wording of the 14th Amendment says any person born in the United States is a citizen of the United States. Now, this was attacked by many people that said, well, wait a minute. You people can't possibly mean to say if someone slips across the border in the dead of night, an illegal alien, and has a child illegally, at 1201 and goes back to, Canada or Mexico or Bermuda at 1202, the fact that that child was born in the United States from an illegal alien and then left, you can't possibly tell me that that person would be a U.S. citizen. And everyone, John Bingham, the major author of the Event Hope, said, of course we don't mean that. That would be crazy. Nobody could possibly think, just because, if you're an illegal alien, you happen to come here, you have a child, and then or say you're not illegal, say you're a visitor, but you're not a permanent resident. You're a visitor. You come to New York on a cruise ship, and in New York Harbor, you give birth to a child, and then you keep going on your way to Canada. Of course, those people are not citizens, said everyone that supported the 14th Amendment. Now, of course, the problem with that is the 14th Amendment seems pretty clear. If you're born in the United States, you're a citizen of the United States. So again, this gets into the question of interpretation. Do we interpret the Constitution as written? If you're born here, you're a citizen. Or do we go back and say, well, wait a minute, that's not what the intent of the framers were. So again, this is a whole, and again, we get more into this, but this is one of the issues of interpretation. Some people would say, wait a minute, the Constitution says what it says. Just apply it. Say, but come on, that first, it's ridiculous. It's idiotic to say if you're born on a cruise ship, you're from China, you're on a cruise ship from Mexico to Florida, you happen to be in U.S. international waters, and you give birth to a child. You can't possibly tell me you're a citizen. That's just stupid on its face. No, yeah, I'm not saying it is. I'm saying this is the argument you could make. That just doesn't make sense. And the framers said that's not what we mean. But you could say, well, if you don't like the 14th Amendment, you shouldn't have ratified it. You shouldn't have put those words in. So anyway, so this is how we came about. So we wanted to get rid of, Americans wanted to get rid of this kind of permanent underclass of non-citizens. They wanted to make sure that people that were at least permanent residents, whether you were descended from Asians or Africans or whatever, if you were a permanent resident, you had a child in the United States, that child was a citizen. So again, that's how, again, you get into this law of the soil and so forth. But that's the background. And then obviously the naturalization laws have changed. I think it was not until the 1920s that non-Europeans were permitted to become citizens, naturalized citizens of the United States. Now again, under the naturalized citizen, the natural born citizens clause and the 14th Amendment, if you were born in the United States, you were a natural born citizen. And again, as I said, that doesn't change the 1920s. And this is another reason why many people think that, again, to get back to the Fifth Amendment, the Fifth Amendment should not be interpreted as broadly as it is. It was not interpreted to prohibit federal discrimination against, other races in terms of naturalization or in terms of just visiting the United States. There's a long history, again, whether you like it or not. I mean, many people would say it's a shameful history, but there's a long history of Congress restricting immigration to non-European. In fact, not even just non-Europeans, actually Southern Europeans were restricted as well. People that, again, for many years, of course, there was a lot of opposition to Italians and Southern Europeans and so forth coming in. But in any event, that's kind of the broad picture. It's a long history, but that's how we got to where we are today.
I see. Okay. What I'd like to do is to compare and contrast the clause, the natural born citizen clause in Article 2 of the Constitution, which was framed by a different set of people than the 14th Amendment, which gave us the phrase due process.
Right.
So I'd like to dive into a bit of history as to why, or the original intent of the founders to use the originalist framework as to the inclusion of the no person who is not a natural, no person except a natural born citizen shall be eligible to the office of the president. I suppose if I can understand them correctly, it's a matter of national interest. They do not want someone who is, well, not of the United States to be the leader of their country. So I wonder if what do you make of that?
Yeah, so again, we don't know for certain because, as I said, there's actually no recorded debates on this at the Constitutional Convention in Philadelphia in 1787. Now, we do have some letters. There were a couple of letters written where people were talking about this between themselves, and it appears that and again, this is a guess because but apparently the reason that the framers put this in was they were concerned that some nobleman from England or maybe Holland would come over and set himself up as king. And there were monarchists in the United States. There were people, in fact, Alexander Hamilton wanted to bring over he talks about this in the debates in the Constitutional Convention. He wanted actually, he thought a king was actually a beneficial thing. He wanted to find some European, royalty and bring him over and become king in the United States. So there were people that thought this. It was a minority view, but apparently to foreclose this, they decided that they would make this natural born citizens clause. That way, some European nobleman couldn't naturalize, some,
Mhm.
prince from whatever, again, from the House of Orange, because you remember in 1689, the House of Orange comes over and takes charge and becomes the new William and Mary become the new monarchs. And anyway, so this there was not it wasn't thought to be a crazy idea that some monarch in 1780, again, remember, just 100 years before, the Prince of Orange had become King of England. So again, there was kind of recent historical precedent for this, and some people were worried about it. There were people like Hamilton that actually supported it. And again, this is all conjecture, but it appears that the large majority of the convention thought, you know what, the best way to do this, to prevent the camel's nose under the tent, because again, maybe some prince will come over and become president before you know what he's going to declare himself king. So, and again, this goes into the titles of nobility and so forth, which is also, of course, forbidden under the Constitution. So that seems to be the background for this. Now, even in 1787, I think this was probably an unlikely scenario, to say the least. I can't see it happening in 1787, to be quite frank. And of course, obviously today it's even less, less plausible. I mean, you can hardly imagine. I mean, I don't know, Prince William or someone is going to come over, run for president, and set himself up as king. So it's a fairly far-fetched scenario. I mean, I understand. I can explain to you the background why there were people that were concerned that there might be a European monarch, but that seems to be the background. And again, you ask me, is it really in the national interest? Frankly, I think the scenario was so improbable that it was not it should not have been a serious concern. But it was for some people, certainly.
Mhm. Okay.
And I don't know if you want me to get into today, but I think as I've indicated, I think the idea today of, some European or I don't know, Chinese royalty, the descendant of the Tsar of Russia becoming king of the United States is extremely far-fetched. And I don't think it's a serious argument.
Mhm. But nevertheless, I'm sure that even today, the United States has enemies, which can be a danger to its national interests. And suppose someone who, even if he or she is a naturalized citizen, still maintains yeah, psychological or cultural ties to his or her home country, then it it can be a danger to, yeah, America's defense of itself in some way, shape, or form. So how do you respond to that?
Well, again, I think I mean, I know you're playing devil's advocate. I don't mean to
Yes.
attack anybody. I think that's a somewhat far-fetched scenario. I mean, the thing that strikes me. I mean, what if someone is a Zionist? Someone like today, of course, there's a huge controversy over American support for Israel. And I say Zionists, not Jews, because I know there are many Jews that don't support this policy. So make clear, I'm not saying if you're Jewish, but if you're a Zionist, as someone who's self-described as supporting the state of Israel, I mean, there are millions of people today, again, who are all called Zionists, who put the interests of Israel above the interests of the United States. You could say those people shouldn't be president. Well, I don't know. Maybe they should. Maybe they shouldn't. I don't know. There should be a law against it. You have a again, I suppose you have a First Amendment right to advocate that. You want to say Israel should should be placed above the United States. There are those who argue that Ukraine is being placed above the United States. People, I've heard many people say, many people in Congress, they're more concerned with protecting Ukraine than protecting America. What in the world is going on here? So I don't think it's an implausible scenario in the sense that are there people out there that seem to put the interests of other countries above the United States? Sure, it happens all the time. But the idea that, well, if someone is a naturalized citizen, they're going to be less reliable. In fact, this is exactly what the Supreme Court in this famous case, Schneider versus Rusk, they said that is an improper inference. We can't assume that just because you're a naturalized citizen that you're going to be less loyal to the American polity than otherwise. And again, look at all the people. I think that the Zionists are mostly American natural born citizens. They weren't born in Israel, but again, maybe tens of millions of Americans are Zionists. They want to put the interests of Israel at least on a par, if not above, the interests of the United States. So again, I don't dispute it can be a problem. Or again, maybe it is. Again, that maybe it's not. Maybe the interests of other countries should be above the United States. I mean, again, strikes me as kind of bizarre. I would think that an American president should be more concerned with the interests of the United States, be interested in the common good of the United States, not of other countries. I would say that's the president's job. His president's job to be president of the United States, not president of Ukraine, not president of Israel, not president of wherever. So I guess the bottom line is, yes, there are people that can put the interests of other countries above the United States. It's a controversial position. But I don't see that natural born versus naturalized is the distinction, is the difference between these two groups of people.
Now, your
In fact, I had one further thing. Actually, there are studies. I don't have the top of my head. I'd have to go up and look them up. But there have actually been studies done that naturalized citizens, as a whole, are actually more patriotic and more sympathetic to the United States than so-called natural-born citizens. People that have come to the United States and decided to become citizens, again, statistically, are much more patriotic than many of the people that were born in the United States. I mean, after all, people, if you become now you may make it up, but if you become a citizen, you have to swear allegiance to the United States, and you have to swear allegiance to all foreign powers. Natural born citizens don't need to do that. A natural born citizen can say, no, I swear allegiance to Israel. I swear allegiance to Ukraine. I swear allegiance to whatever it is, to Vladimir Putin. But a naturalized citizen can't do that. So again, the argument that naturalized citizens are less loyal, actually, the statistical studies that I've seen indicate the opposite.
Okay.
And again, I apologize. Off the top of my head, I can't cite them, but I have seen these studies. In fact, I actually teach a course on this that we talk about this, but again, I don't just remember the studies off the top of my head. But if anyone is interested, you can Google it and you can see some of these studies.
So you mentioned the case Schneider versus Rusk. It was a case in 1964, decided by the Supreme Court. I believe the constitutional amendments being in dispute here is the Fifth Amendment and it's the Due Process Clause, as well as the 14th Amendment and the Equal Protection Clause. So Justice Douglas, I believe, stated that the only difference drawn by the Constitution is that only the natural-born citizen is eligible to be president. So aside from just that, there remains no real difference between natural-born and naturalized citizens of the United States. But nevertheless, you've concluded in your article that forbidding naturalized citizens from being president or vice president is a form of discrimination that limits their options and treats them as second-class citizens. I suppose first you can draw out the background of the Schneider case and later on voice your very strong case against the natural-born citizen limitation.
Right. So there's a lot there to unpack. So in the Schneider case, there was this law that if a naturalized citizen came, someone came to the United States that became a naturalized citizen, and then they left and they went and lived abroad for, I think it was 10 years, they could lose their citizenship. And the Supreme Court in Schneider said that law was unconstitutional because the law, Congress could not treat a natural born citizen differently from a naturalized citizen. So that was the background of the case. This was an illegal form of discrimination. Now, so let me get back to the issue about, there's some comments of the court about the naturalized citizen and the natural born citizens clause. But let me go back, take a step back, and explain more of the background, how this came to be. Because to understand the Schneider case, I think we have to go back in history a little bit. So again, we talked about the 14th Amendment. The 14th Amendment says that no state shall deny any person equal protection of the laws. Now, again, equal protection had its own meaning in the 19th century. So equal protection meant if you had a law that made it a crime to assault white people, it had to also be a crime to assault black people. You couldn't make these arbitrary distinctions. Now, for many decades, the Supreme Court said equal protection does not mean equality, right? So for decades, of course, in fact, there were dozens and dozens of cases. The most famous was called Plessy versus Ferguson. It involved a case where there was a Louisiana statute that required trains to have different cars, like one car for whites, another car for blacks. And this was appellate, I think it was 1897, or I believe that's, I could be off a year or two, 1897, 1896. Anyway, Plessy versus Ferguson was one of dozens, every single state and federal court to address the meaning of equal protection. Every time, I mean, like maybe 100, maybe 200. I mean, there's because this was constant. Discrimination between blacks was rampant in every state in the Union, every single state. New York, Massachusetts had schools that were segregated until 2014. Believe it or not, we finally anyway. But the point is, every state in the Union had laws discriminating against blacks, and every single court in the Union, state and federal, for almost 100 years, dozens, if not hundreds, said equal protection does not mean equality. It's not a violation of equal protection to say blacks and whites have to ride different carriages. Now, in 1954, the United States Supreme Court reversed all of that. It came out and said, actually, in order to get to equal protection, we have to have equality. And this was the famous case of Brown versus Board of Education of Topeka, Kansas, in which the Supreme Court, again, reversed almost 100 years of precedent and said discrimination based upon schools having a school for blacks and a school for whites was unconstitutional because it hurts blacks. Again, that was the reasoning. Again, many people, in fact, Justice Thomas has criticized this, who's himself black, as everyone probably knows. He said, well, that's stupid. I mean, it's unconstitutional because it hurts blacks. That's not why it's unconstitutional. It's unconstitutional because you're discriminating against people based upon the color of their skin. That's why it's wrong, says Justice Thomas. It's not wrong because it hurts blacks. That's just stupid. Anyway, but that's what they said in 1954. So again, but the bottom line of Brown versus Board of Education, Topeka, Kansas, was you cannot discriminate against blacks in a way that will hurt them. And again, this has become to mean you can't discriminate on the basis of race or national origin. Now, in 1954, a companion case to Brown versus Board of Education was called Bowling versus Sharp. Now, Brown versus Board of Education was decided under the 14th Amendment, Equal Protection Clause. Bowling versus Sharp was a case in the District of Columbia. The District of Columbia was a segregated town. In the United States Capitol, they had black restrooms and white restrooms. The United States Capitol, which was built by slaves, by the way, was built in part by slave labor. It's been documented, was segregated. So the U.S. Supreme Court wanted to get rid of segregation in the District of Columbia as well. Now, the 14th Amendment, of course, applies to states. It doesn't apply to the federal government. But the Fifth Amendment applies to the federal government. The Fifth Amendment says the federal government should not deny any person life, liberty, or property without due process. It says nothing about equal protection, as the 14th Amendment does. Now, the 14th Amendment also talks about the due process of law. And so the 14th Amendment has a due process clause and an equal protection clause. The Fifth Amendment has a due process clause, but not an equal protection clause. In Bowling versus Sharp, the Supreme Court just announced out of thin air, well, the Fifth Amendment is the same as the 14th Amendment. Therefore, we will read. Now, again, this somewhat, I mean, at the time it was controversial, and you could still debate it, although it's pretty much accepted. The Fifth Amendment, said the Supreme Court in Bowling versus Sharp, implicitly contains an equal protection clause. This is sometimes called reverse incorporation. So the Fifth Amendment is interpreted to mean the same thing as the 14th Amendment. The 14th Amendment is interpreted to mean the same thing as the Fifth Amendment. So in 1954, Bowling versus Sharp, the Supreme Court says the Fifth Amendment guarantees equal protection, not only equal, and equal protection now means equality. Not so under the Fifth Amendment, the District of Columbia could not discriminate, could not have segregated schools. So segregation in the District of Columbia was made illegal in 1954 in Bowling versus Sharp, the companion case to Brown versus Board of Education. Okay, so that's the first step. Now, 10 years later, in Schneider versus Rusk, they applied that. Again, this was the case where Congress was treating natural-born, naturalized citizens differently. And in that case, the Supreme Court just applied their Bowling versus Sharp analysis. Well, the Fifth Amendment is just like the 14th Amendment. It prohibits discrimination based upon national origin. It discriminates any form of, it prohibits any form of discrimination based upon arbitrary characteristics, such as naturalized versus natural born. Therefore, the Fifth Amendment prohibits Congress or anybody else, the Supreme Court, or again any federal agency from discriminating against people based upon their status as natural born citizens versus naturalized citizens, which again is also a form of discrimination based upon national origin. Because if you're born someplace else, you can't be treated differently. That's discrimination based on national origin. So for both those reasons, all discrimination is unconstitutional. Now, as you said, there's a couple of cases that seem to say in passing what we call in dicta, something that was said that, well, you know, of course we have this natural born citizen clause, and we're not taking issue with that at this point. But again, if you apply the reasoning of Bowling and Schneider, the reasoning is quite clear. The Supreme Court has said repeatedly, it is unconstitutional to discriminate against citizens based upon either the national origin or their status as naturalized citizens. Those are forms of impermissible, unconstitutional discrimination. So if that's the case, then obviously saying that some people can run for president, others cannot, would be unconstitutional. I mean, it'd be like saying Congress passed a law that said no black man may be president. Well, that would be declared unconstitutional. You can't do that. You can't pass a law that says blacks can't be president. That would be nuts. And again, if you accept the Supreme Court precedent, it's the same thing. A law that says, you know, naturalized citizens or someone born in a foreign country cannot be a president, that would be unlawful discrimination, and it's forbidden by the Fifth Amendment, as it has been understood for the last 75 years.
Okay. Now, this is what I would like to end on, the phrase due process, as it is written and understood. So the Fifth Amendment is the one that is for me, the third most popular amendment, aside from the first and the second, because it's the one that criminals use to not answer their prosecutors. I plead the fifth, for example. So from my understanding, the phrase due process means that when you are accused of a crime or wrongdoing, you have the right to a trial by jury and with the assistance of a lawyer or counsel, and you are not allowed. You have the right not to incriminate yourself. But nevertheless, from my understanding, the originalist argument is that this phrase has been expanded to include all sorts of manners of rights that were not enumerated in the Constitution. Say, I suppose the right to birth control, so the Griswold case,
Right.
the abortion, that is the most controversial one, the Roe versus Wade, and gay marriage, Obergefell. So how does due process play into equal protection in the case of the naturalized versus natural born citizenship.
Right. So again, let me take a little bit step back and work my way back there. So one thing, just to again put what you said in perspective, I think what you said is correct. We have to remember that in the mid 20th century, there emerged something called substantive due process. So as you say, the idea of due process is historic. This is a concept that goes back at least 1,000 years, right? In English legal, in fact, actually goes back to the Romans. There were certain procedures that were basic and fundamental to any legal system that was worth its weight and and again, those were things like you said, some of these things, the right to cross-examination, in English law, the right to a jury trial. Again, but these were procedures. Now again, in the 20th century, the courts decided there was something called substantive due process, that due process included not just procedures as had always been understood, but included substantive rights, that there were certain substantive rights which were so fundamental that they were somehow implicit in the idea of due process. Now, again, as you say, not only originalists, but others have criticized this, and Scalia often criticized this in his decisions. He said, substantive due process is a contradiction term. You have substance and you have process, and they're two completely different things. And again, many people thought that, but that's where this comes from. So substantive due process is a new term. Okay, now again, go back to the Snyder case. So this is the way that the courts shoehorned, at least in 1954, in the Bolling case. This is how the courts shoehorned the denial of the legality of the segregated schools. Again, it was a hard enough case to make that equal protection of the laws prohibited discrimination, which is again, every court decided and said no, that's not the case. So, but 54, the court says equal protection is violated by having segregated schools, and so was due process. Because again, the assumption was, and as I said, I mean, I don't know how else I can explain it, that the court simply asserted, without really any argument whatsoever, we can't say the states are not allowed to discriminate and let the federal government do it. We just can't do that. Therefore, we're just telling you, are telling you, due process also on the federal level, in the Fifth Amendment, also prohibits discrimination based upon status or national origin. So again, that's what's the reason for it? The reason is that's what we want. We can't. Segregation is so awful. We just have to bend the rules to get rid of it, no matter what we have to do. In fact, we can raise taxes. Courts raise tax. Again, this is one of the things about segregation that, again, I've been studying this for many years now. Again, one of the criticisms people had, I mean, courts literally raise taxes to pay for schools. That had been illegal for centuries. When Charles I tried to raise taxes without the consent of Parliament, he was killed. They cut off his head. They said, you can't raise taxes without the consent of the people. You're crazy, King Charles. You're a dead man, King Charles. They killed him. For this had been American, remember, taxation on representation? Remember that? One of the reasons the American Revolution. So again, the point was, nobody defends segregation. We all recognize that was a stupid, ridiculous, evil thing to do. But the point was the courts bent themselves in knots. They raised taxes. They made up whatever rules they had to get to the place they wanted to go. And again, this remains controversial. But where do we get substantive due process? Well, that's where we get it. Some things were just so bad, we were going to get there no matter what. So I don't know if that, again, if that's a satisfactory answer, but that's historically the way it happened. It's just like, okay, this is terrible. We need to do something about it. And we're going to bite the bullet, and we're just going to do what we need to do to get there.
Okay. I suppose a Supreme Court case in the future involving directly the question of the naturalized versus natural born citizen distinction were to be decided, then it'll be, I think, the definitive answer, whether it is the natural born citizen clause in the Constitution, Article 2, is constitutional, basically.
Well, but of course, there's never any definitive answers because
Mhm.
this court can change its precedents. But yes, you're right. I mean, it would be very interesting to see the Supreme Court take this up. And again, I said there's some people like this Dr. Shiva I mentioned. I understand he's got some cases working through the courts. Um, and it may be that one day the Supreme Court will say, yes, we think natural born citizens clause is unconstitutional. It does violate the Fifth Amendment. Now, again, it's interesting to go back to the originalists. So Justice Thomas, who's really the main, maybe Gorsuch, maybe I don't know. Again, there may be one or two others that may be originalists, but Thomas has in fact criticized this whole substantive due process. Thomas has argued that, for instance, discrimination based upon race should be found to be contrary to the privileges and immunities clause of the 14th Amendment. I think it's actually much more powerful, makes a lot more sense that discrimination actually violates the privileges or immunities of American citizens. He says, give it all this substantive due process nonsense. I don't want that. In fact, he's been critical, again, Justice Thomas has been critical of Brown versus Board. It's like the whole reasoning doesn't even make sense. He said explicitly in a number of cases discrimination should have been held. It should be held to violate privileges and immunities, not substantive due process, not equal protection. So if you took that, and again, if this were to come before the courts, I mean, Justice Thomas, or if there were other originalists, they might say, you know what, Brown versus Board and Bolling and Schneider are overruled. It's got nothing to do with equal protection. So anything's possible. I mean, anything's on the table. And I'm saying there are some different interpretations. But again, as I said, I argue in my article, if the Supreme Court was simply to apply the precedents, the Bolling and the Schneider precedent, to me, clearly indicate how the case should come out. But as always, courts can overrule their precedents and they could turn around. And again, maybe Justice Thomas will have his way and say, you know what, I don't think there's anything substantive due process. I don't think Bolling was properly decided. And again, that's an option. So it's hard to predict how these things will change. Again, I think a lot of things have changed quite a bit, obviously, in the last 75 years. Again, in the 1950s and 60s, um, there was just it was almost a civil war in this country over school desegregation. Remember, I know again, in fact, when I was growing up, I mean, when I was growing up, I grew up in Columbus, Ohio, in the 1970s, and I can still remember it was hugely controversial. So Columbus never had segregated, and again, this is to get into too much background, but I think that just to kind of put all these arguments in perspective, in Columbus schools were never segregated by law, but like many big cities, the inner city tended to be black and the suburbs tended to be white. This was hugely controversial. Federal courts in the late 1960s ordered Columbus to take white children out of the suburbs and bus them to the inner city, and take blacks from the inner city and bus them to the suburbs. This was incredibly not only controversial, it was detested. Parents, black and white parents alike, they hated this. They hated seeing their children go on school an hour a day to go across the city. It was extremely unpopular. And as I said, judges even raised taxes to pay for it. Joe Biden came out repeatedly against this, against school busing. Joe Biden, in fact, this brought him to fame. They had Wilmington, Delaware, same thing. Wilmington, Delaware had been segregated, and they had busing in school. And Joe Biden supported a constitutional amendment to allow basically forbid school busing. People hated school busing. In fact, Congress passed a law in the 1970s. The federal funds could not be used to enforce busing. Again, it was hugely unpopular, including Joe Biden. But so again, I say you have to remember the atmosphere back then. People thought that segregation was so terrible. And I'm not saying it wasn't, but the segregation was so terrible, people would do anything. And some of these cases from the 50s and 60s, including the Supreme Court said in the late 1960s, federal judges can raise taxes. Again, if there's anything, it's un-American. It's unelected people raising. That was right. The American Revolution was largely based on no taxation without representation. Only our representatives can raise taxes. Well, the Supreme Court said in the late 60s, federal judges can raise taxes. So again, a lot of these things were really not only pushing the envelope. I mean, they ripped the envelope open. So again, to put this in perspective, there's a very different attitude today. I think people have hard time understanding. And again, I was only a child in the 70s, but even I remember the controversy, how upset people were furious about school busing. People were furious about segregation. I mean, the country was being torn apart. People were so upset about it. I mean, I guess the country is being torn about today for other reasons, but again, the point is, I want to say that you have to remember the context a lot of these decisions were made. Would they be applied today? I'm not sure, because we live in a very different historical era. The things that were tearing the country apart, 50 years ago, um, fortunately not tearing the country apart anymore. But again, we have other things tearing us apart. So how would the court decide? I don't know. Would the court go back? Like, for instance, one thing: if today a federal judge tried to raise taxes, I bet you dollars to donuts, the Supreme Court would say no. We overrule that precedent. Judges cannot raise taxes. That's just beyond the pale. We're not going to let judges raise taxes. I think that would be overturned. I don't think a judge has tried to raise taxes in 30 or 40 years. I mean, they only did, again. The court said segregation is so terrible, we're going to let judges raise taxes. And I don't think that precedent would be applied. So the bottom line is, I don't know. Some of these precedents, again, substantive due process, I think may be on the ropes, frankly. Justice Thomas and others have been very, very critical of this whole idea of substantive due process. And so I wouldn't be surprised if we do see a significant change in some of these cases.
I think that's a good note to end on. Thank you very much, Paul Clark, for joining this program.
Okay, well, thank you for having me.